Good morning, Mr. Darton.
Yes, my lady.
We've had an opportunity, well, some of us at least, to read quite extensively into this matter, and on that basis, we'd be grateful. Sorry, that's shining in everybody's eyes. We'd be grateful if you would begin in relation to your first ground of appeal by explaining to us why it's appropriate that you should be allowed to take that point at this stage, especially as I certainly have read the transcript which was provided to us yesterday evening, and it doesn't seem that this issue was raised below.
Well, my lady, you are quite right to have highlighted the fact that some of the grounds of appeal are put on alternative hypotheses. My contention is that the consent order contained an agreement that was binding on the parties that meant they were to proceed on the basis that an occupation rent was payable. However, it would have been remiss of me had I not reminded the court that although one can proceed on the basis of that concession, the true legal position may be otherwise. Therefore, when confronted by an argument on this appeal that, as it were, there was no concession, it seems to me that one has to, in my respectful submission, either say, right, well, we have a given basis upon which the trial judge proceeded. And if that's not right, then one says, well, okay, then what was the true basis? In fact, I suspect one of the reasons why the learned judge fell into error is the concepts got mixed up.
Well, let's start, therefore, with your second ground of appeal, which is this is the agreed basis on which the matter went ahead, i.e. The recitals to the consent order and the memorandum of agreement itself. And certainly, I think we've all read the relevant parts of those documents. And as I say, I've had the opportunity to look at the transcript and the way in which that was dealt with, that issue was dealt with before the judge. So as you suggest that that was the basis, assumed basis on which the trial went ahead, let's explore that second ground of appeal and then come back to the issue that you raised in the first.
I'm grateful. From your ladyship's comments, I assume that the court is therefore obviously seized of the wording of the consent order, which appears at page 96 of the core bundle. And the memorandum, which I think is referred to as a schedule, that appears at page 75 of the supplemental bundle.
Yes, which isn't very helpful. Anyway, yes, so that's, I'm sorry, page 96 and supplemental bundle page...
75, my lady.
75.
This is where the, if any, in parenthesis comes in.
Yes.
Now, it's a matter of construction. But I submit that when one looks at page 96 of the core bundle, the first thing to ask oneself is, well, what is the purpose of that acknowledgement? Because it very definitely formed part of the agreement that was made. I would respectfully suggest that the learned trial judge treated it as having no value whatsoever. I would submit that when
maybe because he allowed the concession to be withdrawn and it wasn't opposed by your client.
Well, he doesn't, in his judgment, he doesn't, my lady, he doesn't deal with that in his judgment. There's no recording of that concession being made.
No, but one's read the transcript and it's obvious that, the concession was withdrawn and that you didn't oppose it being withdrawn.
Well, my lady...
So I am, speaking entirely for myself, a little puzzled as to why, on that basis, you're even entitled to raise this ground.
Well, my lady...
Because if that is the case, if that is the correct way of looking at what happened in the trial below, if there was a concession in the recital and that concession was withdrawn, the judge allowed it. It doesn't matter whether he said so in his judgment. That is what happened.
Well, of course, my lady. But then let us step back from there for a moment. So let us say that there is no concession in play. So on what basis does the trial judge proceed?
On the basis that there is no agreement binding on the parties, that there is a right of occupation.
And then one comes back to, setting aside for a moment before one even discusses whether I can argue the point or not, if I could just take it back one stage, my lady, jurisprudentially, where does that then take us? Where does the judge start? In my respectful submission, he or she has to start from the premise, well, what is the true legal position?
Yes, Mr. Darton, but the point is, isn't it? All the parties come before him, he reads their skeletons, and the basis of those skeletons are whether or not occupation rent is payable, and if it is, how much. There is a purported concession to say that it is payable and that the only question is how much. So it's the what rather than if. He deals with the issue of the concession and concludes that he will allow it to be withdrawn. So he's then dealing with if and what, or how much. And that is what he does, because that is what is presented to him on the basis of the skeletons that were before him below, and on the basis of the Part 8 claim, which provides at paragraph 2.3 that it is that the claimant, now the appellant, is seeking an account. So that's what he does. I fully understand that what you say in relation to your ground one is, but that was all totally misconceived. But, and we're putting that issue on the shelf at this very moment, and we'll come back to it, don't worry. But in relation to that question that you were asking, and in relation to your second round of appeal and the concession, the point is that that is how the judge proceeds. He deals in his own way, having heard what was said about the concession, and concludes that he is able to address the if question as well as the how much, what question. And he does both. That's what happens.
Well, my lady, clearly that's a correct summary. But given that the trial judge is dealing with the if,
Yep.
one then has to analyse whether he approached the if correctly.
But you're taking us back to round one, and I put it on the shelf, Mr. Darton.
Well, I hope I'm not, my lady. What I'm trying to mean by that is this. It's plain when you look at these lines of cases that you have different issues going on, for instance, when the claim is brought by a trustee in bankruptcy, than you have when the claim is being brought by two cohabitants. There are different issues in play.
Mm-hmm.
In this instance, if one is considering the if, one then has to look at the circumstances in play.
Which he does.
Well, my respectful suspicion, my lady, he gets it wrong.
But that's your third ground of appeal. There isn't an ouster.
It's more than there is.
Or there is an ouster.
Yes, but it's more than that. It's in this instance, So within the context of occupation rents, one can look at it in all sorts of ways. In cohabitants, one looks at it as a question as to, originally it was ouster, and then it moved on to whether parties could in fact occupy together. So you have that issue going on. And then you can turn it in sense of, has the remaining party done anything to justify the occupation? Or you can turn it around in the other way, saying, well, did the other party, could they have properly occupied? So you can do it fault-based, or you can, however you want to do it. In the context of a trustee, different issues apply. Whether you call it occupation, different issues apply. One, because the trustee doesn't appear under the authorities to engage Talata.
Mr. Darton, you're now addressing the first question, which is, in fact, whether occupation rent was the right course at all. And you're also addressing the issue about whether the parties were the right parties to be claiming. And therefore you're saying, if you were going to do the if question properly, if you were the judge, you'd be thinking about all of these things. And you're saying, in effect, therefore, the judge did not consider these things. But that is, as I see it, a ground one issue. And the point about all of that is that we are standing in the shoes of the judge at the moment, because we're considering ground two, and then the further issues about how he dealt with the matter on the basis that he thought applied. And in that regard, we're looking at what actually happened and what he was encouraged to believe was the right way forwards.
Oh. Well, my lady, forgive me if that's how what I've said has been understood.
I'm sorry.
No, and
if I've misunderstood.
Even if that is the objective understanding of it, that was not my intention.
Right.
My intention is to say that even when you go to ground two, you have to distill down the relevant circumstances. You have to distill them down because even on the authorities, the tests may be different, but certainly the way you apply the tests will be different. So I'm
sorry, I'm already off track, because ground two is there was a contract, or you're stopped from denying that all this was really about was quantum and nothing else. You'd accepted that this was the basis, occupational rent was payable, and all we were there to do was to determine how much and set-offs, etc. That's ground two, that's the basis of the agreement. It wasn't anything, as I understand it, to do with anything more philosophical than that. Let's put it that way.
My lady, you have I fully understand the points that are being made. I am seeking to move down before we go back to argue those points, as it were. But even if one goes to ground three,
yes,
the factors that I submit were in play were firstly this. Up until the order was made in the probate proceedings, the appellant could not even have sought an order for sale.
Is that the way that you put it in your skeleton here, in relation to ouster? It's all on the issue of whether the judge was right to conclude that there was an ouster on the facts. You don't say whether there was an ouster or there wasn't an ouster. You don't go into the juridical basis in that. It seems to me that you're trying to infect all of the grounds of appeal with your first ground, which is this was all misconceived.
My lady, forgive me, it wasn't infection, it was informed.
Mm-hmm.
And paragraph 17 of my skeleton, at page 23, I hope, raises this point. This is under my ground 5, some other justification.
Okay.
So, ignoring the other points as they stand as points, if one is considering whether to award an occupation rent, I contend that one of the factors, and indeed I would submit probably the most powerful factor, is the fact that in this instance, this party, unlike a trustee in bankruptcy, does not have it in his power to even realise the property by sale.
Neither do any of the others. The only person who would have the power to sell the property would be the executor of the estate. And if the executor isn't moving fast enough, you have remedies against the executor.
Well, my lady, I would of course accept that in the period from 2014 to 2016, when there was a change in the administrator.
Mm-hmm.
But in relation to the period up until 2014, and we see that...
Well, everybody thought in the earlier period that you were operating under a different will, which was subsequently set aside.
Well, I don't think everyone, my lady, if I might just say, I don't think that is fair, because I don't think it can be said that the appellant was operating under the assumption it was a different will. The appellant was seeking to set aside the will and was vindicated in that case.
He didn't seek to set aside the will immediately, though, did he? I can't remember when the proceedings began. Was it
Well,
2012, 2011? So we've already had 5 years or so.
well, my lady, that would be an issue which would go perhaps to quantum. But if we are arguing this, or I'm arguing this, and only allowed to argue this on the basis of, well, this is a claim for occupation rent between parties entitled, equally entitled, then one question I submit that must be considered is the extent to which I could realise my interest by sale.
And is it your case that the judge failed to take that factor into account when he exercised his discretion?
Yes, my lady.
Did anybody mention it to him? I don't think it's in the transcript. We have to be terribly careful not to reinvent the circumstances of the trial here and the way that the matter was put by everyone. And let's begin again, Mr. Dawson, because I think we've fallen into a number of rabbit holes along the way. Let's begin again, which is where I started out at least, which was with your first ground of appeal, which is, in fact, that this matter should have been looked at completely differently, and this wasn't a question of the occupation of co-owners or anything akin to that, and therefore the judge was wrong. And my question in relation to that, let's take it off the shelf. My question in relation to that is, why should you be allowed to say that now? And can you show us how it was dealt with, if it was, on that basis below?
Well, my lady, taking it in stages, and I would, in relation to the transcript, I would wish, if I am allowed that opportunity, to go back and reconsider it, because this has been a late addition to the bundle, and I want to get my pagination right, etc. But dealing...
Well, it was, I accept that it is a late addition to the bundle, but the pages, etc., are in your opponent's skeleton, the references, and presumably you had access to the transcript before.
My lady, I would submit, starting with the Part 8 claim, and I've heard your ladyship's observations, that first of all, that was wide enough to embrace a claim put on either basis.
It just says account in paragraph 2.3, doesn't it?
I submit in the context of a Part 8 claim, that is wide enough to include that. But that's my first point.
But in relation to that, I would ask you, it is a Part 8 claim, and someone also looks at the witness statement served with it as evidence for it, and I don't think, unless you correct me, that you'll find in those witness statements in support of the Part 8 claim any reference whatsoever to trespass or mean profits.
My lady, I don't suggest that.
Mm-hmm.
But if I may be at least given this much, as I understand the case that's being put to me, it is not suggested until prior to the date of the trial the concession contained in the consent order had been withdrawn. So plainly that concession would scope the way that the case proceeded to trial.
Are you saying that this was a point that was only taken at trial?
My lady, I'm submitting that
that there was no forewarning before the trial that the defendants were going to seek to withdraw the concession.
I tread carefully, my lady, because I was not counsel at trial.
Yes.
But as I recall, I think it's paragraphs 11 and 12 of my learned friend's skeleton argument. He seeks to withdraw the concession that was made. Now, I think that's in the supplemental bundle, my lady.
Yes.
And I hope we find it at page 290. Now, I don't want to mislead you, but I'm going to assume the fact that when the date of this document was drafted, it was thought necessary to remove that concession. Suggests that until that point, the parties have been proceeding on the basis of what is contained in the consent order.
Well, one doesn't know, because one doesn't know what was in correspondence between the solicitors, whether this was foreshadowed. One simply doesn't know, one way or the other.
Well, I submit, my lady, it is the most likely inference to be drawn from paragraphs 12 and 13 that
Yes.
counsel then acting in the case felt that he needed permission to withdraw the concession. That until that point, the matter,
If
concession
necessary,
was still
she should be
correct.
given liberty to withdraw her admission on the basis it was based on a clear error of law, and its withdrawal would cause no prejudice. All right, well, let's assume that application by Mr. Sharples is flagged up for the first time on the 9th of July. That's pre-trial. So there's an opportunity to consider whether to oppose the withdrawal of the concession or to let it go, and what prejudice might be suffered and what arguments might be put. And counsel then acting decides, in effect, to accept that there is no prejudice, and the judge decides to allow the concession to be withdrawn.
well, my lady, I was trying to take the matter at stages. My point was in response to the state of the pleadings and the witness statements.
Yes.
I think it is, if nothing else, a fair answer to that point at least.
I may be being rather slow, Mr. Darton, but as I understand it, your ground 2 is based upon the terms of the order, which is regarded as a concession, which was withdrawn before trial and effectively withdrawn before trial, or at trial.
I think at trial, my lord,
At
is
trial.
the correct position to take.
What I'm not understanding at the moment is how, in those circumstances, you can rely upon the terms of the order as a ground of appeal?
Well, as I recall the law in this area, that it's not an absolute bar where that occurs to taking the matter on appeal.
If the agreement, the withdrawal of the concession means that the agreement, any agreement that appears to be included in the terms of that order has gone, how then can you rely upon that agreement as a ground of appeal in this court?
Well, my lords,
I mean, if the answer is you can't, we can strike out ground 2 and move on to the other grounds, remembering that there was once a purported agreement in the terms that we've seen.
well, my lord, if I can, it may be that is correct, but if
Well, is it or isn't it?
Well, unless you're going to allow me to argue it as some exception, then yes, it's correct. But if I might, for one moment, just pick up on the word purported. I appreciate this was a concession, and what's being said against me is it was a concession which you agreed to, as it were, concede, and I may well be stuck with that.
Well, are you? I mean, do you say you're not stuck with it? I may well be is not very helpful for someone who's struggling to understand your case as I am.
I don't press the point at this juncture, if I might be allowed that much, but what I was seeking to do earlier and clearly failing, for which I apologise, is simply this, is that the fact that there was a concession, and I would ask you at least concede me that, explains how the case gets to trial.
Well, there's a badly drafted consent order, which is ambiguous. There's a recital which appears on its face to suggest that you have got a right of occupation, which we're all, I think, agreed is probably wrong. And then there is something in the body of the agreement which says rights, if any. And the two can't live happily together.
Well,
and at least... speaking for myself, I thought recitals were supposed to be secondary to what's in the body of the agreement. So you've got to give the words, if any, some meaning, even if the concession hadn't been withdrawn. But anyway, it was withdrawn.
And in fact, that's what the judge does, isn't it? Because he takes it in the round as a whole, mentions if any, and says, and moves on. So that's the way, that's at paragraph 37 of the judgment. Read as a whole, it's clear that the liability referred to is in respect of occupation rent, if any. If I'm wrong about that, and the question does arise on the facts of this case, then I would, in any event, decline to make an award. So that's the basis. And I'm afraid also, Mr. Darton, the way in which this matter arose and was dealt with, if one looks at the transcript, is at 114, it's the issue about the wrong basis is taken by Mr. Sharples, and then he says it's a clear error of law. He accepts that there was ostensible authority and in effect there was an admission. That's at F, and he mentions withdrawal of that a little lower down, and he deals with that over the page, and at 115 he says, I would submit that there's no prejudice which is being suffered. So he's going through why he should be allowed to withdraw the concession. And if one looks, for example, at 136, or a little bit before that, 135, there Mr. Kember is referring to the agreement and the recital, and then he says there was ostensible authority at the top of page 136. He says the request to withdraw has been made orally, and then he doesn't make particular criticism of that there hasn't been a written application. Then at CD he says he deals with the prejudice point and makes submissions about that, and the judge says well, I've got no evidence about that, about the kind of prejudice you're referring to. And Mr. Kember says no. And that is how the matter was dealt with. And then the judge and the parties moved on, and he dealt with it in the way that we know he dealt with it. So it seems to me that you may say that explains how they got to trial, but once you were at trial, that matter was addressed, and therefore the remainder of the trial was on the basis that the gate was open, if you put it that way, that one needed to argue on the basis that the concession had been withdrawn or was permitted to be withdrawn.
My lady, I had not intended. I had intended to move on to engage in the other grounds. What I'm seeking to submit, though, is that when one comes to look at the other grounds, one still has to consider the circumstances of this case. And there are some peculiarities about the circumstances of this case that arise out of the fact that it is a round peg in a square hole or a square peg in a round hole. Now, the judge definitely does that because he talks about his discretion and he talks about the rise in price. So he definitely approaches the case on the basis that he should be applying co-ownership occupation rent principles.
Yes.
And I don't understand myself from being precluded from saying, well, he got that wrong in the following respect.
No, but please, we're mixing the colours on the palette. Let's go back to what my Lord Justice Stuart-Smith asked you, which is about ground 2. We've been hovering around ground 1 and ground 2. In relation to ground 2, we've been exploring that, Mr. Darton. And so, really, in relation to that, let's conclude some discussion and some argument about that. What do you say about ground 2 and about the position in relation to the way in which it was dealt with at trial? Are you still saying, nevertheless, you're entitled to rely on the memorandum and the recital as if it were a contract or there was some sort of estoppel?
I can't rely on it for that purpose unless I'm allowed to withdraw the concession, and I concede that I'm not going to prevail in such an application.
Sorry, just let me understand what you just said. You're saying you can't rely on it as an estoppel or a contract unless you are entitled to...
Well, I would have to withdraw the concession previously.
What concession?
What concession?
No, not your concession. We would have to rule that the concession made by the other party could not be withdrawn.
Or that the judge was wrong to exercise his discretion to allow it to be withdrawn. I
think where we've got to, Mr. Dutton, is as things stand, you accept that ground 2 cannot succeed as a freestanding ground of appeal.
Yes, madam.
Thank you.
Thank you.
It does have some relevance, which I'll come back to. But yes, my lord, I'm grateful for that.
Thank you.
But, and I'm sorry it's taken us so long to... but if I take you perhaps to the judgment, to look at the other grounds and to see the way the judge approaches, and this was all I was seeking to do, was to submit to the court that the judge is proceeding on the basis of joint rights of occupation.
Yep.
If that's right, and we set aside ground 1 for the moment, we then have what I submit is one of the most powerful factors in the case, which is that my client can't realise a sale until at the earliest 2014. And the reason I say that's right, my lady, and the reason I say that point was in play, is I take you to paragraph 38 of the judgment, if I might, And this is at page 49 of the core bundle. Because this point definitely was argued.
Before you do this issue, you say, goes to what?
Round 5.
Ground 5.
It would go to ground 5 if one then goes to the ultimate, if you like, the ultimate discretion. How does one exercise the discretion?
And so you're saying that the discretion, which discretion, as to whether the principle applies at all or how that principle should be exercised?
Depending on whether you're under the statute or depending whether you're not and you're in equity, which
For these
the judge
purposes,
seems,
you're not, aren't you? Because
well, there
Or are you?
I'm fearful of answering the question in the way I would in an exam paper. If I'm answering the question in the way that I am now restrained.
I'm a bit confused, and I'm sorry. I apologise to you for asking you this, but if what we're doing at this stage is looking at the way in which the judge looked at it and parking ground 1, which is your point, which is that he was set off on a hare which he shouldn't have been set off on. So he's looking at it on the basis that all 4 beneficiaries have occupation rights. Is that right? Is
Yes.
that the basis? Right. So he's looking at it, what, under Talata or outside Talata, or a bit of
I
bit
don't
of
think he
each?
chooses between them, as I recall it. I
Right.
don't think he actually makes a decision.
So ultimately, he's exercising a decision or making a decision on the basis of justice and equity, which is essentially the test under both.
Well, there, my lady, there are passages, if you'll permit me, I would like to take you to in the case of French and Barham, talking about the exercise of discretion. I think the word I used is it's not an untrammeled discretion.
Right. All right. Well, let's agree at least on this. He is exercising a judicial discretion, and would you accept that where a judge exercises a judicial discretion, there are limited bases on which, in an appeal court, you can challenge the exercise of judicial discretion?
Yes.
You have to show that the judge failed to take into account a factor he should have taken into account, took into account something he didn't, or reached a decision which is, to coin a phrase, perverse, outside the ambit of what a reasonable decision maker should have done. Now, speaking for myself, looking at your ground of appeal, I find it a bit difficult to unpack that, to see it as a challenge to the exercise of judicial discretion on any of those bases. But no doubt you'll enlighten me as to which, if any, of those you're taking.
Well, my lady, I will do my best.
Yes.
The first is that in relation to those 2 bases, I would, if I may, suggest the third, which is that the discretion was exercised on the wrong basis. So you have said you consider factors you shouldn't have considered, or you failed to consider factors you should have considered, and that's why. And if I satisfy you of that, then as I've understood the law, you have the power to exercise your discretion de novo. The second category, my lady, which of course I accept, is this was an extraordinary exercise of discretion which no properly directed tribunal could have arrived at.
Yeah.
But there is a third one I would respectfully suggest, which is that the discretion had to be exercised in accordance with certain principles.
Yes.
Mm-hmm.
I seek to persuade you that I can establish each one of those. And what I would like in that regard to do, if I could just trouble you to open up the authorities bundle, is to take you to the case of French and Barham, which I hope is in your tab 13. A decision of Mr. Justice Macklin. Now this is a case, and you will, I hope, have recalled that earlier I remarked upon the fact that you do seem to have 2 lines of authorities running in relation to occupation rent. One in relation to trustees, and the other in relation to cohabitants. Now, fortunately, we have a head note here, and so if my ladies, my lords, you wish to get up to speed in respect of that. But the points that I wanted to refer you to is, firstly, if I could take you, and this is page 190 of the bundle there, which is paragraphs 43 and 45. There, Mr. Justice Blackburn held what, in a sense, this court has already remarked upon, which was that in that case, it was argued that everything was ultimately a matter of discretion. But if I take you down to paragraph 45, you will see there that Mr. Justice Blackburn held, of course, it does not follow that because the facts of this case are materially indistinguishable from the facts of another, that the decision in this case will necessarily be the same as in that other. But it does entail that some valid ground for departing from the decision in that other case, assuming it applied the correct principles, should be established. I'm not persuaded there is any such ground. So if this is all about just discretion, then we won't have these cases troubling this court again. You will have these cases troubling the district judges and the circuit judges an awful lot.
But
Because
it will always depend on the facts of the particular case. But I can well see why you'd take us to paragraph 45 of French and Barham if you said, and there's another authority which deals with precisely this case in which the discretion was exercised in a particular way, and counsel below invited the judge to do the same, and he didn't. Is that why we're going here?
We're going here, my lady, because unless you are going to say that I'm not able to argue this appeal at all, one of the issues which, as I've understood, I am able to argue is the question of the exercise of discretion.
Yes.
Your ladyship was good enough to identify two categories, and I have suggested a third. What I haven't so far been challenged on is the suggestion that discretion is untrammeled. And I'm assuming...
No doubt you're going to assist us by identifying the principles that you say affect the exercise of the discretion and where we find the source of such principles.
Well, my lady, I'm grateful for that. So, yes, within French and Barham, we have at paragraph 34, which is page 188, I hope, of your bundles. And this is what I would submit is, as it were, the test as regards trustees, and I would submit also applicable as regards the appellant and those who are residuary beneficiaries.
This is about trustee in bankruptcy, isn't it?
It is.
Yeah.
Now, my lady, the only case which both sides seem to have discovered to deal with more precisely these points is Creasy and Salt, which I haven't taken you to yet, because for fear of being told, well, that's your ground one. My point, however, is the judge, when he exercised what he called his discretion, was obliged to properly categorize the status of my client in relation to the property. My lady, what I mean by that is this. Firstly, if there are rights of occupation and I appreciate we're in an artificial world, but if there are rights of occupation, then they can only be under the will. It is the 1997 will that gave the parties any rights over this property. That's the first thing. The second thing is that for a substantial period of time, the second respondent is occupying the property as if he is the absolute legal owner. And we have the registered title to that effect.
Because he believes he is.
Well, the next point is we have the decision of the probate registry, which declares that he isn't. Those points in my respectful submission are essential to the proper exercise of discretion.
Well, you wouldn't even get a claim off the ground if, unless he's a trespasser, would you?
Sorry.
Well, if he has a right to occupy the premises, don't you have to say that he's a trespasser before you can claim mean profits or rent from him?
Well, this is the effect of the concession that was made by my predecessor. And this is why I said there was an artificiality. And this is why I'm trying to tread so carefully between these various bases.
Yeah.
And on my reading of the judgment, the judge was not persuaded that the only issue was trespasser and is that pleaded. I don't see any decision on that. So the way he proceeded, which he was invited to proceed on, was this is a co-owner's case. Now, there are, and we can go to a case that I'm sure that the respondents will rely upon, which is the case of Davis and Jackson. There are differences of approach. But if I am limited to attacking the way the judge proceeded, then I respectfully submit that I am entitled to say, well, okay, so if we are proceeding under what we all appear with the benefit of reflection to agree was the wrong basis, maybe not in this court, but if we were asked to put in our own exam papers how we would answer the question, then what are the factors that are relevant?
In a co-owner's case.
In a co-owner's case, but not necessarily a cohabitant's case, my lady. I don't think we made that concession. So there are different criteria going on.
And what you say is, on that basis, when you were considering the exercise of discretion, you would be taking into account those three factors which you've drawn to our attention, and the judge didn't, so QED is wrong.
Yes, and if I might, I would develop them a little bit further than that if I can. The first is that, and I noticed this in my learned defence skeleton argument, how the parties got on pre-will, what the testator would have wanted in relation to the house. This is the point about, oh, well, she would have wanted the house to the second respondent to keep living in the house until it was sold, etc., etc. None of that's relevant or admissible. It's the will and only the will. I wouldn't have thought this court would want to encourage litigation where parties go, oh, well, I know that's what it says in the will, but what the deceased wanted was this. So that has to be taken out of the equation. On the basis of the concessions, and I agree that it's intellectually uncomfortable, my lady, I accept that, it can only be the will.
And no doubt you'd say that's the way it was approached in Crescent Soul. The judge says there's nothing in the father's will that gives any indication that Michael was allowed to occupy the land. There may be something in relation to the way in which the will of the mother was structured.
Yes, I mean, I think there are, I think there's all sorts of ways you can deal with it. Well, there's two ways you can deal with it. You could deal with it in a very practical way. And you could say, in effect, what was the practical situation in terms of the occupation? Now, when you're dealing with cohabitants, that's, as it were, what you're primarily doing. You can, of course, with cohabitants, and I think this is reflected in the Act itself. Of course, you look at the purpose of the trust. So, if one, for instance, is dealing with the Davies and Jackson case, you have the peculiar circumstances of that case. That although the bankrupt co-owner had, courtesy of the TR1, a 50% share, it was acknowledged that he had never occupied and the property had never been bought for his occupation. Now, I would respectfully suggest that there is a tension between that approach in Davis and Jackson and, in fact, the approach in French and Barham. Because in French and Barham, the argument that was being made there was that the trustee in bankruptcy stepped into the shoes of the insolvent husband. So in other words, the trustee could not enjoy any greater rights. And in French and Barham, Barcham, Mr. Justice Blackburn said no, it's effectively ground zero from the insolvency.
But this isn't an insolvency case.
My lady, I of course don't seek to persuade you of that. What I seek to do is to draw comparisons between that and these circumstances, because this is not a cohabitants case. So if, unless I'm to be told that I must treat this case as it is a cohabitants case, which, as I say, I don't understand the position to be.
Well, it's neither cohabitants nor trustee in bankruptcy, but then you go back to the basic rule that if two people own a piece of real estate and one of them is in sole occupation of it, you've got to show something more than the fact that he's in sole occupation of it for the other person to be able to claim a mean profit or a rent. And that's the start of the whole. You then have to look at an equitable reason why he should.
And there's something more, my lady, is the fact that I am kept out. Not only do I say, and I appreciate the judge made a different finding, but not only do I say I'm kept out of occupation, because it would be utterly unrealistic for me to occupy, and the judge made findings as to the breakdown of the parties' relationship as a result of the probate proceedings. But more than that, I say that my position is I'm in a far more egregious position than the trustee, because I can't move to sell the property. The passage, well, my lady, I can't, because I first of all got to get the 2003 will revoked.
But was this inability to sell mentioned as a factor before the judge?
Well, my lady, I'll have to return to that.
I don't think it was, Mr. Darton.
But what was said against me, my lady, is if I might just, what was said against me, and this is in the judgment. So when the judge goes and says, it's in his judgment, and this, if I might take your my lord, my lady, is to page 49 of the core bundle. In fact, it's page 48. Now, this is a paragraph 36. You'll see that there the judge held it does not amount to an exclusion or restriction of Farzand Ali's right to occupy under the statutory regime. He and his siblings had such a right, but such a right was not an exclusive one. That was unrealistic, given that he and his own family, he had his own family home, and that Mr. Ramzan, who had a similar right even under the 1997 will. And then he says, according to my judgment, the first requirement for an award of either an occupation rent or statutory compensation cannot arise. It cannot arise under the recital to the order. And so he's dealing with that as if the order is still in play, and that's a question of construction. And then he says, if I'm wrong about that, so, my lady, with regard to the concession, as I say, the judge isn't just dealing with the question of the consent order in terms of concession, he's also dealing with it in terms of construction.
Yes.
I contend that it's quite clear how one reads that order, but I won't return to that now at this moment. What I do say is, look what he then goes on to find. If I'm wrong about that, and the question does arise on the facts of this case, then I would in any event decline to make an award. The claimant received for the share the sum of £80,000. He then refers to valuations, paragraph 38, and then he refers to Davis and Jackson, Mr. Justice Snowden. Well, as I say, I think there is a tension between the approach of Mr. Justice Snowden, as he then was, and the decision of Mr. Justice Blackburn in French and Barsham. But if I can then take you to that paragraph that he himself refers to and persuades him on, as he says, is a powerful factor in the exercise of his discretion, could I please trouble you, if I may, to take you back to these authorities, and this time, if we could go to tab 19, please.
Before you do, Mr. Darton, and I'm being very slow, what is the proposition that you get from the passages in the judgment that you've just taken us to? Why are you showing us these particular passages?
I'm showing them to you, my lady. I hope, and forgive me if I'm not succeeding.
Because I thought you were showing them to us to show that there was a passage in which the judge had made a finding that your client couldn't sell the property, and that was a point that was issued, that was argued before him. But speaking for myself, I haven't seen anything in that passage that you've shown us to say anything of the kind. That's why you took us here.
My lady, I took you to these passages to show what I would contend is the decision of the judge.
Yes.
And then if we go on and we look at Davis and Jackson at paragraph 38, we see that plainly in the exercise of his discretion, one of the factors that preyed heavily in his decision not to award an occupation rent was the rise in the value and the fact we had received £80,000. And in support of that, to say, well, that is an appropriate way to proceed, he cites a passage in the judgment of Mr. Justice Snowden, as he then was, in Davis and Jackson. What I had then proposed to do was to take you to that passage and to respectfully suggest that the learned judge was wrong in the way that he treated that passage, and that he ignored the paragraphs which precede it, which show precisely why that point was not a good one.
And so this is in fact a different point from the point that you were making before, it seems to me, and no doubt you will take us in a moment to Davis and Jackson, the paragraph which is quoted at paragraph 38 of the judgment, and the way in fact you say it's dealt with in the case as a whole, and that's about the 80,000, revolves back into the £80,000. But as my Lady Justice Andrews was saying, the point that we were on when we came here was the nobody's taken into account the fact that my client couldn't move to sell the property. And I said in relation to that, but I don't think that was raised below, Mr. Darton, and that's why you came to the judgment, and I don't think that you'll find it's in the passages that you've referred us to or anywhere else in the judgment. I just want to know what your submission is about that before we move on to Davis and Jackson.
I don't suggest in the judgment that the issue of my client's ability to sell is considered.
And do you accept that it wasn't raised?
I don't have material before you to suggest it was raised.
Well, that's. Do you therefore accept that it wasn't raised?
I would wish to go back to the transcript, but I'm not going to assert the contrary at this juncture.
I'm now totally, speaking for myself, totally confused. You say this is the bull point. The judge got his discretion completely wrong because he ignored the major point, which is my client couldn't sell the property until everything panned out and probate was obtained. If that was the bull point, I would have expected it to have been A, argued below, and B, considered by the judge. I can well understand that if the judge in his judgment says nothing about it and it was argued below, he might have a good point. But now you're telling us that you can't say that it was argued below, in which case how can you criticise the judge for not taking into account a factor that, that your side, and it's not you personally, previous counsel chose not to regard as the bull point?
My lady,
Strikes me as being a little difficult.
Is not whether he failed to take account of the point, although that is an argument, but you're still left with the fact that he did take account. Indeed,
he did what?
He did take account, my lord, of the rise in the value of the property as being a reason.
That's a different point.
Well, my lord, yes, but they are two sides of the same coin, if you'll forgive me. He cites French Barham. I was about to take your lordships, your ladyships, to that judgment, and to say that his approach to that, his adoption of that passage in the decision in French and Barham as being good for his decision, is wrong, and his consideration of the £80,000 is wrong as well.
Okay. Well, forgive me for a second time, just trying to see whether we can put a lid on a particular box. I think, having started off by saying that it's a major point that the appellant couldn't sell the property, you accept that that wasn't dealt with in the judgment, and you are not in a position to assert that it was raised before the judge. Full stop.
If put in that way, my lord, but it does have the converse. This is what I'm trying to say, is that...
Let's just pause there. You accept what I've just said.
I'm obliged to accept what you said.
That's fine, you accept it. So now where do you go from there?
Well, where I go from there, my lord, is I say that the factor that the judge did rely on was wrong, and within that, it ignored our inability to realise the property. So in other words, if you want to rely on paragraph 69 of the judgment of Mr. Justice Snowden, as he then was in Davis and Jackson, you have to read the preceding paragraphs. And I contend it's quite clear from those preceding paragraphs that there the increase in value of the property was found to be a reason not to award an occupation rent, precisely because the trustee had delayed in applying for sale. And it set out the trustee had the power to effect a sale. And
so that's a basis, you say, for distinguishing Davis and Jackson on its facts. And you say that the proper way, the way in which one looks at Davis and Jackson is you don't look at the fact that the property has increased in value in isolation, but you also take into account the fact that it would have been possible to have realised it sooner.
Yes, my lady.
But of course, ex hypothesi, if it was realised sooner, it would have got less money because it's increased in value.
Well, yes of course, my lady. But
so, if the judge is taking into account the increase of value, as Mr. Justice Snowden did in Davis and Jackson, the delay in realising the property has caused no prejudice to the person who is complaining about it, because he's got more than he would have done if it had been sold earlier.
Well, my lady,
that's what Davis and Jackson was all about.
Well, my lady, I submit Davis and Jackson was about more than that. And in fact, that's not an answer necessarily in all cases. We don't have the findings of fact. If as a result of general rises in property prices, the value of my client's interest in the property has increased by X percentage, but in fact, he would have invested it in another property and therefore still enjoyed the same thing, he has not enjoyed a benefit. The situation is neutral. So the reason why the increase in value becomes relevant is because you add in, as your ladyship observed, the fact that I could have realised my investment. It's those two factors that come together. If I can't realise my investment, then I say that the dicta in Davis and Jackson does not apply. Because otherwise, and maybe that's what this court is going to find, but I say it's not Davis and Jackson, that somehow a general rise in property prices is a reason not to award an occupation rate. And I submit that's not the law, and nor should it be.
Well, I think what he was actually saying was not the general rise in property prices, but as a result of the general rise in property prices, the fact that he was kept out of his share of the quarter, his quarter share for as long as he was, is not something to complain about. But I think the judge goes further than that and says, because he's got that amount of money, he would be overcompensated if he also had mean profits over the same period, because he is benefiting from the capital increase, and therefore he would be doubly compensated for the delay if he were also to receive a rent in the period in between. Speaking for myself, I can't see anything illogical, incoherent, or contrary to principle in that approach.
Well, my lady, if I can start from, first of all, whether whether Davis and Jackson is good authority for that proposition, I submit that it's not. And if I might take, I notice, my lady, you are at that case. I hope the rest of the court is. It's page 435 of the digital bundle.
Before you do any of that, is there not an element, and I might be wrong about this, that in fact £80,000 was in any event an overpayment in the light of the actual valuations which had been received? And so that is another element when one is looking at the 80,000, that 80,000 was actually generous as a quarter share given those valuations. So that is another issue.
Well, my lady,
I think that's right, Mr. Dalton, isn't it?
Well, my lady, I think we have to be careful in relation to that. It's right that the valuation we got, if that was the right valuation.
Well, we can only go on the valuations
No.
got.
But my lady, my simple point is that let us not look at something with the benefit of hindsight. At the date the parties agree this price, they don't know what it is. So they both take a risk. The valuation then comes along. So,
Mr. Dalton, this is spin. I understand exactly what you're saying. When they agreed their price, they just agreed their price. They didn't agree to overpay. They didn't think they were overpaying. But what was before the judge was, on the basis of the valuations which had been obtained and the figures that were available, it looked that 80,000 was generous, let's put it that way. And he took that into account, and he was entitled to do that, was he not?
I would submit, firstly, no, because it is simply, the parties have dealt with it. If one looks at that deal that they made, my lady, they made a deal that the 80,000 was paid, plus there would be a claim for occupation rent to proceed.
If any.
Well, my lady, we can...
Well, that's what we're stuck with. So, but occupation rent, if any. And
yes,
that would ultimately be a matter for the discretion of the judge, who might decide that none was payable.
Well, that is the first thing I'm seeking to. I'm not allowed at the moment, and I accept that I'm restricted, to argue what was the effect of the consent order for the purposes of the trial. I accept that. That doesn't, I would submit, preclude me from arguing that the consent order in its proper meaning isn't relevant to the exercise of the discretion, which I am allowed to argue. What I am saying is the agreement that was made provided for 80,000 plus, at the very least, a right to argue for the occupation rate. And it was, as the court has already observed, clearly the parties didn't know the figures, so they were, on both sides, taking a risk. So I submit that the fact of that overpayment, if it is subsequently shown to be the case, shouldn't be taken account of because the parties have agreed that it won't be. But if I'm wrong on that,
Well, they haven't agreed that it won't be, have they? Where did they do that? Sorry.
well, this is where we go. This is where we go to the point about if any, and I say the effect of it goes to quantum. But even if I'm wrong on that, and let me pitch my case a little lower than that. If I'm wrong on that, that might be a reason to reduce the occupation rent, the if any. It wouldn't be a reason to disbar me from an occupation rent.
I'm lost. We're not now talking about the 80,000. What you're talking about is if any. And in relation to if any, you're saying that means it must be some rather than an ability to say it's nil, it's naught. Is that what you're saying?
Well, my lady, there are two. I'm saying, firstly, that my position on the construction, because I don't want to be said to have made a concession here, whatever the position is, my position is that the order, as read, plainly meant that the only question on the occupation rent was quantum. And one sees that because if, for instance, one looks at the skeleton argument of my predecessor, he addresses at length the counter claims that he thinks are going to be set up against it. I then submit, as a secondary position, that if it is found that I have been overcompensated, as my lady put it, and I'm prepared to accept that without it being seen in any sort of then that would be a reason to reduce the occupation rent that I might otherwise receive.
Well, it depends on how much you were overcompensated by. You see, I think it's inherent in that submission that you're accepting that it would be a relevant factor for the judge to take into account in the exercise of a judicial discretion as to what was just and equitable, to say you've actually received more for your share of the property than you should have done. Next question is how much more have you received and how does that bear on the question of whether you should get compensation for not having been able to sell it earlier or however you want to phrase the claim for occupation rent or mean profits.
Well, my lady, I had forgiven me. I had got to 2 points in response to this very good point that's been raised for me to deal with. My third point, which is why I say it shouldn't be taken account of at all, is because I submit the increase in price is only relevant where it is combined with a failure or a decision not to apply for sale. And I say
Which
that,
is back to your Davis point.
yes. So
And what is the principled reason why you say it's only relevant? Let's forget Davis for a moment. Let's suppose you're right on Davis and Jackson, and that is the reason why Mr. Justice Snowden approached the matter in the way he did. I'm interested in the principle. Why, as a matter of principle, would it be wrong to look at the increase in value only if you can't sell the property earlier?
because I'm entitled to take my interest as I choose it. The court shouldn't attempt to value my interest. It is only, so in other words, the respondents have done nothing to give me a benefit. I haven't asked for that benefit. I haven't encouraged that benefit. If one looks at it in restitutionary terms, this benefit has been bestowed as a consequence of rising house prices.
Yes.
So in restitutionary terms, as I've always understood it, it's not just that I've received a benefit, but it's one that I've been encouraged in some way. It's that combination. The law does not, in general terms, penalise parties for receiving a benefit that they haven't in some way acquiesced at the very least in. So one takes it in the simplistic terms. If you repair my house, then so what? If you repair my house and you don't pay me the rent, and you turn around and say, well, I've repaired your house, so I don't have to pay you any rent. And the answer to that, as far as I understand the law of restitution, is to say, but I didn't ask you to repair my house. I didn't encourage you to repair my house. So those repairs could not be set off the rent liability.
It depends very much on the facts.
But also, what's restitution got to do with this?
Well, I was invited to, I think, forgive me if I've misunderstood, to give a jurisprudential answer. I'm submitting that fundamentally, under equitable principles, it is not the bestowing of a benefit that gives you credit. It's the bestowing of a benefit where the recipient of that benefit has invited it, acquiesced in it, so as it were to give rise to some form in the widest sense of an estoppel. Because if I'm wrong about that, then the example I gave, I submit, becomes a very valid one. It is an answer to any claim for rent, arrears of rent, to say, oh, but I've repaired your property. And the response to that is, but I didn't ask you to.
It's not even analogous, Mr. Dunn, because what you're dealing here is with the effect of the delay. I mean, Davis and Jackson was all about the fact that it took time to realise the property, and then the question is, should there be any kind of compensation for the impact of the delay? And if the property goes up and you could have sold it earlier, then the answer to that, as a matter of judicial discretion, was no. But it's not to do with restitution.
But, my lady, even the term delay can have, I would respectfully suggest, two meanings, two connotations. There can be delay as just explaining the passage of time, and there can be delay in the context of failure leading to the passage of time. In Davis and Jackson, there was a delay in the second sense of it.
And there is here, except that the person who doesn't realise the property is the executor rather than your client.
Well, my lady, that might be an answer, although I'll return to it, but that might be an answer for only a period of time. It cannot be an
after
answer.
2014.
It can't be an answer up until 2014.
Can I just, forgive me for interrupting about once every half hour, but I just need to see if I'm still in the right case. As I understand it, your submission on this point is, in answer to the observation that your client had the benefit of an increase in property prices, you say he couldn't sell. But there's no evidence of alternative use if he had been able to sell. Either by way, so there's no evidence that you've been disadvantaged. So in this respect, you've had exactly the same advantages as the other three beneficiaries. What you complain of, as I understand it, is not really about the increase in property prices, but that Mr. Ramzan has had an advantage which the other three, and in particular your client, haven't had, because he's had the benefit of non-rent paying occupation of the property. Have I understood the position correctly?
Well, again, and I'm sorry to always answer it, but like all good questions, in my submission, they admit to more than one answer, or they raise more than one issue. Yes, you are right that you have 4 siblings, all of whom have enjoyed the increase in the property prices. So that is correct. One of whom has enjoyed the occupation of the property as well.
Yes. And that's what you're complaining about.
That is one of the things I'm complaining about, my lord. But with regard to the evidence as to, as it were, what we might have done with the money, I submit that since it is tolerably clear that all we're talking about is an increase in property prices, there's no findings of anyone did repairs or there was some property development or something that took it ahead of the market.
So there's nothing to show that your increase in your benefit from the increase in property prices disadvantaged you because you would have put the money to different use.
There's nothing there. By the same token, I turn it around and say there's nothing there to say we wouldn't have achieved the same result by investing in another property.
So it's neutral.
So it's neutral.
Fine. So your complaint is simply, it's nothing to do with property prices, it's to do with the fact that one of the siblings has had the advantage of occupation. Full stop.
Yeah.
Well, on a practical level, yes.
That's a good start.
My lord, of course. But my lord, is this any different from a trustee in bankruptcy? A trustee in bankruptcy comes along, and in some instances a decade after the event, and says, well, I want the increase, the uplift, and I want an occupation rent. And French and Barham suggest, in fact, there's almost I think it is, there's a presumption that that's what should be payable. Now, your lordship's observation would be a complete answer to the trustee's claim. Because unless you have additional requirements, that's it.
Well, that's
now,
putting it a little simplistically.
Well, every argument gets to a point of reductio ad absurdum, my lady. Every argument does, but that doesn't mean it's not a valid argument. There is a practical implication, if that's the important thing, which is it's one of the burdens this court bears that your decision will, of course, influence other cases. What I'm submitting...
Well, it may or it may not. It depends on how fact-specific it is, and whether in fact, if it's a case of a wrong exercise of judicial discretion, may be very fact-specific.
Well, my lady, yes, it may, but it may not. I can't put it any differently than that. But what I'm submitting is where the law now stands, is that it's not enough just to have the increase. You have to have the delay, and the delay means fault, or a conscious admission, or just an admission.
So you're saying that Davis and Jackson lays down a general principle of wider import to that effect, are you?
My lady, I'm saying the position is French and Barham. I'm saying the position is that we cannot be in a worse position than a trustee. French and Barham held that a trustee had a presumption of getting an occupation rent. I'm saying that if you ratchet me back and say no, we prefer the approach in Davis, I'm contending, well, Davis does not take you as far as this court has taken me in argument, and I'm submitting there's a very real jurisprudential reason why it doesn't, and I'm submitting there's a very real practical reason why it doesn't.
But isn't this all fascinating but irrelevant? Because it is on the basis that in addition to the 80,000, which took into account rises in capital property prices, your client was entitled to occupation rent. French and Barham, you say, in addition, can be in no worse a position than a trustee in bankruptcy. Let's put aside all our worries and concerns about many of those stepping stones along the way. But assuming that, you say, therefore, just saying 80,000 wasn't good enough. You need to go on and look at the occupation rent element. French and Barham, not Davis. But, as I mentioned a little bit earlier, the 80,000 the judge found was actually, it's not just increase in property prices over the period, it's also considered to be generous, an overpayment, and an increase on what would have been, on the basis of the valuations before the court, would have been a quarter share. So there's fat within that 80,000, and that is what the judge takes into account. Are you saying that he can't take that into account when looking at how to compensate overall?
Well, I can, again, forgive me, if I can separate out those 2 points. The first thing is I must address, given the requirement of a judge below exercises discretion, to address you on what I contend the judge did with the merits of what your ladyship says is an alternative basis. I say what the judge did is he treated the whole of the 80,000 as it were, determining factor in the exercise of his discretion. That is what he did, that's what he said. He refers to Davis and Jackson, and I say he got it wrong for the reasons I've outlined. If I persuade you to revisit that decision, then the question becomes in, that your ladyship, I have understood, has raised with me is, well, is it a factor to consider? In other words, will you have been overcompensated in that way? I contend, I hope simply as a matter of logic, that if you were to take it as a factor, it must be a factor to reduce the occupation rent, not to extinguish it.
Which depends how much overcompensation, doesn't it?
Well,
You can reduce to naught if one has been paid £1 million and one's share is worth £10. It might take you to naught.
well, of course, my lady. But by the same token, if you've been overcompensated by £10, it shouldn't be a reason to debar you from recovery at all. All I'm saying is, yes, you would have to do the calculation. And it's not a difficult calculation to do if one accepts the valuation of the property, and then one can do the maths on that. I'm not subject to my earlier arguments, which I won't repeat because I don't think it's going to be well received, but I simply say that would go to reduce the amount. But none of that matters if this court finds that there's no reason to interfere with the judge's discretion. But I say this judge did not do what your ladyship has suggested might have been a proper way to proceed. That's not what he did.
Well, if you look at paragraph 43,
That's exactly what he did.
that is what he did, isn't it? That's why I'm confused.
My lady and I are in a very similar position in that regard, because that's how I read it too.
Well,
Okay, he didn't carry out a balance sheet approach. He didn't set one thing against the other. He didn't, therefore, carry out a detailed calculation. But he looked at all of those elements and did what he considered to be broad justice, having looked at the rental values in paragraph 42.
well, my lady, I say the maths there just doesn't add up, because on our figures, I think we're looking at a sum of around 50,000. We've received 80,000. We weren't overcompensated by that amount.
Says he takes a very broad view.
Yes, but a very broad view. I'm not suggesting a broad view, but a very broad view, my lady, is not permissible.
And so are we saying actually that that was an incorrect exercise of discretion because what? Because he didn't take into account
He should have done a mathematical exercise.
the precise figures.
Well, my lady, what I'm first of all saying is that the judge approached the question of the increase in value on the wrong basis. And this is my point in relation to delay in his reference to Davis and Jackson. He did not approach it in the way your ladyship has elucidated. He didn't.
Well, that's what he says he did in 43.
Well, I submit that is a catch-all, my lord, simply saying, well, this is in a very broad way.
Yeah.
Where he's exercised his discretion on a broad basis. You say if he'd done a mathematical calculation, he would have realised that even if there was a degree of overcompensation, it didn't justify reducing to zero what the occupational rent he should have awarded.
But I say what, yes, my lord, that is one of the things I say. But what I also say is that he treated it, clearly I submit on this judgment, you know, the passage that he takes out as being that the rise in the property value can be a reason not to award occupation.
Well, in that case, all of those paragraphs about with other figures and about rental values, actually, he wouldn't have bothered to put in, would he? He'd have said, "That's that. Thank you. Draw a line."
Well, my lady, he does not, in the judgment, approach the matter by addressing the question of why it is in Davis and Jackson, Mr. Justice Snowden, as he then was, made the remark that he did.
I think we've got that point. I think, and what you're saying is, in Davis and Jackson, it was the failure to take action.
Yes.
Earlier. Yes.
And you
We understand that.
But I also say on this, and I think there is a point here which is in play, which is, I say that this is an instance where there is a clear tension between the judgment of Mr. Justice Snowden in Davis and Jackson with the earlier judgment of Mr. Justice Blackburn in French and Barham. Because plainly the judge does not approach it in the way that Mr. Justice Blackburn did, of saying, well, in effect, there is a presumption.
But he's covered it by 43.
Well,
The whole point about taking a broad approach is that there is in his paragraph 43 a broad assessment both of capital value and rental value. So he has accepted in principle the possibility at least of rental being recovered.
well, you have my points on that, and I say that.
Well, I'm not sure I do.
Well, I say that is simply a catch-all that he says at the end. He doesn't attempt the maths, and I say he would need to attempt the maths. It's not a very broad exercise. But what he certainly doesn't do, my lady, is that he does not adopt the presumption in French and Barham. And because in French and Barham, if I could take you to tab 13 of the book.
This is your ground four. It is actually, one should start from the premise that occupation rent is due, rather than start from the premise that it's not due and you need a factor. It's French versus Davis. That's your point.
It's my point, my lady, yes, but within that point, it seems to me self-evident that in the French and Barham situation, there will always be double recovery in the sense of increase in property price plus occupation rent. Or rather...
It's not double recovery. Your whole point is it's not double recovery.
No.
It's two different things.
No, that is my point. What I'm saying is that the approach of saying the rise in the property price excludes the occupation rent is contrary to French and Barham. Well, it must be, my lords, because
I understand that.
And therefore, when one goes to the approach of the judge, he prefers Davis and Jackson.
To the exclusion of what you call French and Barham.
Yes, he doesn't treat it as if, well, actually, I have a presumption here that I ought to follow. And I submit that this scenario is much more analogous to the trustee.
I think it is putting it a little high to say that French and Barham gives rise to a presumption. You can say that the general thrust of the approach that Mr. Justice Blackburn adopted was that if the situation were analogous to a Reed Byford type case, then you would normally exercise the discretion in the same way. But I don't see anything in his judgment that talks about presumption in favour of granting occupation rent.
Well, I've set out the citations where I say that I mean, this is paragraph 34 of the judgment, my lady. I can do no better than refer you to that. I would submit that it does amount to that, but because I just look at the words, it would normally be fair or equitable to charge the occupying co-owner an occupation rent.
So this is 34 French.
This is 34 of French, my lady, yes.
Mm. Okay, I think we have that point, and I'm concerned that we have interrupted excessively, and that time is ticking, and I just want to do a little bit of housekeeping and see where we are. It seems to me that we have been covering the ground in ground 4, not ordinarily, if not invariably, payable, which is what you've just been addressing, which is French versus Davis. And I think that you've also dealt with ground 5, which is some other justification, which you say, well, I'm not sure whether it goes there, that you say actually the issue about not being able to seek an order for sale and therefore failure to proceed, and that takes you back to Davis about how you look at the capital value. So I think that goes to ground 5. I'm not sure whether you want to add anything else in relation to ground 5, but ground 3 is, I think you have also covered, but I just want to be clear about that.
I'm grateful. Well, can I, so how I approach the judgment is having been to these passages, he, at the concluding paragraphs of his judgment, the learned judge, essentially says, I have a discretion. And that's what ground 5 is about. And I've addressed you in the way that he treats that discretion, I hope. Why I say to you that in fact that was not it. The way he treated certain factors was simply wrong.
Certain factors, the 80,000.
The effect of the agreement, the fact that the general rise in property prices per se was relevant in that issue. With regard to stepping back to before you get to that point, and the judge jumped over it in a sense, he didn't really properly address, in my submission, ground 4, which is what's the right test. And you can have some sympathy with him on that, because as a result of concession and the withdrawal of concession, which is then accepted, you have, the more you delve down into the jurisprudence of it, the more difficult it gets. But I contend that before he got to the discretion, he should have been approaching it on the basis of what I call a presumption, and I of course accept my Lady Justice Andrews' observations, but I say that is clearly what French and Barrow means.
Yeah, well, we have those submissions. I'm just trying to.
The other points that if I might go back to the question, which I think I may have, in the way that they've been put in, is I submit that the learned judge was obliged to consider and only consider the rights under the will. So in other words, where the passages talk about parties leaving and, well, you had another house to go to, etc., that was irrelevant. And this is following on from the French and Barrow point, because you, as it were, start from ground 0 as a consequence of the will. So where he considers those factors he shouldn't have done.
And where's that in the grounds?
I think Forgive me. Sorry, my lady, I fear I may have confused my own offence submissions with the judgment. But what I contend is the point is, it can only be the will.
And I was asking, where is that in the grounds?
So, my lady, maybe I thought there was a passage about how the children moved out.
I'm not looking at the judgment, I'm looking at your grounds. Where, under which ground does that come? You say he should only have taken into account the will, all this evidence about toing and froing and what people thought or wanted, all irrelevant, is what you say. But where does that fit into your grounds?
I think it was paragraph 4 I was referring to in the judgment, my lady, for what it is.
And your grounds, Mr. Darton?
My lady, if you will give me that a moment. Well, this I would say is within ground 4. And I'd say it also falls within ground 5.
I was going to say I couldn't find it in 4. The nearest you can get to it in 5 is the last sentence of paragraph 16.
I find that difficult, but I hear what you say. And so, just so that I'm clear, have you therefore?
Oh, sorry. I think. Sorry. Certainly, I've been reminding my skeleton argument. I certainly under ground 1. I've been told. Paragraph 25. I appreciate that's not the question you asked, but if I...
No. Have you covered all the matters that you consider relevant in relation to grounds 3, 4 and 5?
In relation to ground 3, I don't believe I have. And I'll deal with it just very shortly in this way. I submit that the decision in Kingsley is authority for the proposition, good authority, that where a party has 2 bases for occupying, one of which would give rise to an occupation rental, one of which might not, the court begins by looking at the basis upon which they occupy. And here, from the date on which that registration was made on the title, the second respondent was not occupying by reason of his rights under the will. Well, the 1997 will. He was manifestly occupying, as a matter of the registered title, as absolute owner.
But that's because there was a misapprehension, and it wasn't until after that that the will, which is 2005, I think, on which he was relying, was held to be invalid. And so the circumstances are completely different, are they not, from those in Kingsley and Kingsley, which was partnership property?
Well, my lady, I'd say not. I mean, you must take the consequences. It can't be whether you believe that what you had the right with, that what you did was right as an answer. The question is, on what basis were you occupying?
Well, we now know that the only basis upon which he could have been occupying was under the will.
But the basis upon which he purported to occupy was under the earlier will and as absolute owner. And so for the purposes of the discretion, the factors that one has to consider, I submit that was relevant and should have been taken into account.
So are you saying he was occupying as a trespasser, or are you saying that he was occupying as a quarter share owner rather than a full share owner?
Well, I think my lady knows the answer I would like to give.
I know,
So
but I'd still like to know what the answer is that you are going to give.
then I shall give it, my lady, and that is this. That factor was relevant to the question of ouster.
No, Mr. Darton, that is not an answer. The question is, in what capacity was he occupying? Was he occupying as a trespasser, or was he occupying as one of 4 co-owners of the property, or in some other capacity?
He was occupying as the... So he wasn't occupying with the other sibling.
No.
He would be a trespasser.
So he was. So the answer to my question is he was trespassing. He didn't have a license from anybody to be there, and the fact that he had a quarter share in the property under the will didn't entitle him to be there.
That I would say is the effect of Creasy and Sol and Creasy, my lady, yes.
Right.
Because he's entitled to a share of the residue. And I submit it's quite clear on the judgment of Mr. Justice Morgan that does not bring with it a right of occupation. I haven't addressed you on that case for the reasons the court is aware of. But you've asked me the question, and that must be the right answer. And that may debar me, because of what went below, from arguing that point in front of you now, but it is still relevant to the exercise of the judge's discretion, even when he treated the case as between people who were entitled to all co-own, because he had to look at the legal position as well as the practical position.
He was treating them on the basis that it appeared to be common ground before him that they each had equal rights of occupation. So that it was a co-ownership but not cohabitation case.
My lady, we've addressed that, and yes.
But that is right, isn't it? I mean, in terms of the way that the judge approaches it, it's very easy with the light of hindsight to say, well, even if he didn't treat it as a Talata case, he should still have said, well, he was a trespasser. In a way, that becomes a circular argument, because the fact is that as the case was presented to him, it was presented as a co-ownership, not cohabitation case, in which they all had the right to be there. I mean, the irony is that if he didn't have a right to be there, neither did your client.
Well, no, and this would be the point I think was taken earlier as to who would have the lockers to bring the claim.
Well, the executor would, but we haven't got there yet.
Well, no, my lady, and then we come on to what was the effect of the consent order, about which we're in disagreement, and then we come on to the point of the date of the trial, the consent order, whatever it meant, upon which we disagree, then returned us to ground zero, and then we proceeded on that basis. But in fairness to my predecessor, he did, and he is recorded in the judgment as having said this, paragraph 19, this is page 46 of the score bundle. Mr. Kember realistically and properly accepts that the facts of this case do not amount to what he called a classic constructive ouster of Mr. Farzand Ali from the property. Nevertheless, he says that what happened is sufficiently close to justify such an award. And what I'm saying is you have to look at the legal position as well as the practical position. When you take those factors into account and you bear in mind what I say is the presumption in French and Bow, the judge got it wrong, even before we move to the discretion.
Can I, have you finished on that submission? Could I take you to paragraph 42, please? In the hope that this is of some relevance. You've got 4 siblings. So if you're right, and the occupation generates a right to occupational rent, then you would take the monthly rent and divide by 4, and each sibling would notionally have the same entitlement to a quarter. So your client's entitlement, if you win hands down and it's got to be calculated, would be for 1/4 of the going rate for a certain period.
Yes.
So we've got 2 rates in the first 4 lines, 500 to 950 as between 2 experts over the period 2006 to 2018. So one, without being too finicky about it, one could say, well, we're looking at about £800 maybe overall for the whole period if you just equalise it over. Then you've got 800 to 1,000 to 1,200, where I suppose you could, if you were looking at it with a reasonably, not too broad brush, say, well, call that 1,000 a month. So that would be £250 as your client's entitlement per month over the period. Okay, have I understood the position correctly so far?
Yes.
Thank you. Then there's the question of what period you're claiming for, and I understand that to be 2016 to 2006 to 2019, or possibly continuing, but starting in 2006. What is the significance of the judge's observation, 5 lines from the bottom, that Mrs. Bibi intended that Mr. and Mrs. Ramzan would live in the house until it was sold? Does that mean that there wouldn't be an entitlement to occupational rent for a reasonable period until the house was sold?
Well, your lord, I think that I'm not sure is the answer, but what I think it certainly means is the judge felt that was relevant.
Yes, because in any civilised family arrangement where you knew that the testator's will was that although the house should be sold, the a sib should live in it until the house is sold, no civilised family is going to, never mind the legalities of it, no civilised family is going to start demanding rent during that period. So what would you say is a relevant period, 2006 to 2010? I'm just trying to get a handle. I know I'm going back to what we discussed before.
Well, you'll forgive me, but I'm afraid I can't. I will answer that question. In fact, I'll answer at discretion. I would have thought 2 years is appropriate to administer and sell a property.
So on your case, we're looking at something in the order of 10 years at those figures, a quarter share of 10 years.
My maths is always terrible, but I think it's a bit more than 2000, so I would go to 2008. So we would say from 2008.
You'd take it from 2008 till when?
Well, until judgment.
Thank you.
Could I just say this and forgive
Why
me?
not until the sale of the house?
Well, no. In fact, you're right. You are
So
right.
when was
It
the
must
house
be
sold?
until
Got to be until the house is
consent
sold.
order.
Well, the house is notionally sold, surely,
Yes.
at the latest by the
Yes,
time of the
sorry.
settlement agreement.
Forgive me, my lady. You are entirely right. Forgive me, my lord. It would be the consent order because then I've realised my interest.
Okay, that gives me what I wanted to know when I come to see whether I agree with your submissions about paragraphs 38 to 43.
My lord, I'm sorry. Forgive me, but yes, in very broad terms. But can I just say this, because the observation was made that in a sense we didn't bring the probate proceedings at an earlier stage. It said, well, you didn't commence the probate action to set aside the will until we're damned if we do and damned if we don't. We did not, because my lay clients sit behind me, we did not embark upon this litigation without giving more than a decent period of time. And indeed, we didn't embark upon the application for sale until after a new administrator had been appointed, and there still wasn't a sale.
Answer.
And if I could again, because my lay clients sit behind me, as I'm sure you will have noticed, the property was originally owned by my lay client's father. He gave it to his father. So from their perspective, it is very galling.
But that's long ago. And that isn't something that you're suggesting, is it?
No, no.
Was a relevant factor. So we.
No.
Thank you.
But what I'm trying to say, my lady, is it's always this that when one looks back, it is easy to reinterpret matters. All I'm submitting is yes, there is a humane period. There is an administrative period. This court is more familiar than I am on the sort of periods that it would take. I would suggest 2 years as an appropriate period. I don't deny that. I do, however, and forgive me for returning to this, and forgive me for not knowing the judgment as well as I would have wished, but paragraph 42 again returns to the point that I sought to make earlier about Mrs. Bibi's wishes are, in my submission, not relevant to the exercise of discretion. The period of grace, that is relevant. And the reason I say that Mrs. Bibi's wishes are not relevant is that's a very, very dangerous ground to go down. So yes, period of grace, yes, we offered it, we say. This wasn't litigation that was undertaken lightly. We were vindicated by the 2014 judgment.
Can I therefore just take you back, I'm so sorry, to your pinning on 2008. That's 2 years from 2006, which is the date of the death of Mrs. Bibi. What is the relevance of the fact that at that stage the 2005 will was alive and kicking, and under that will, of course, the property it goes to Mr. Ramzan, absolutely. So 2000, what do you say is the effect of those facts upon your choice of 2008?
Well, I think one simply has to leave it out of the equation. I think that will was invalid, and it's just binary, it's as simple as that. I'm suggesting the period of grace in any probate matter is appropriate. And that's consistent with all the cases. You look at what you could easily...
But on that basis, I'm sorry, and you're saying, therefore, it's the 1997 will, and it's two years from the death of Mrs. Bibi. Okay. And you're saying, therefore, you ignore the factual context.
Well, I think you must, save for its effect on my client's ability to realise. And the reason I say that is because otherwise you're going to get into... Well, no, my dear, because practically that is objectively ascertainable. We could not move for sale until we have resolved probate. But if you go down the route of saying, oh, well, the will, they were acting under the will, then you go into the dangerous territory of whether they were legitimately acting under, whether they, in other words, it was failed for want of knowledge and approval.
Okay, but you're accepting a period of grace of about 2 years.
Yes.
In advancing the case on behalf of your client, you're accepting a period of grace of about 2 years.
Yes. But I'm saying there were good... But, yes. Sorry, my lord, but I'm just saying it... forgive me, and it's perhaps not my place, but if one tries to rationalise this to go forward, I have set out what I think are the appropriate principles to approach such a matter. So you have to ignore what the testators said about the property if it's not in the will, because otherwise you'll create a satellite litigation. You can accept a period of grace, because not just because it's humane, but also because you got to administer it. I mean, I think that, well, is it the executor's year? There are others who will know this much better than me, etc. So you can look at it in those terms, and that is justifiable. But then you go on, and we've had this discussion, well, property prices rise, and we just say, well, so what? And then we have this point, as I've said, well, we can't access our money.
Okay, now, time is really ticking. So, and there is no more time, in the sense of today is the day. So, have you said everything that you want to say in relation to grounds 3, 4 and 5?
Might I just take a moment, please?
Mm-hmm.
No.
No, you haven't said what you want to say.
Yes,
you have.
No, you have my submissions on those points, as are also set out in my skeleton, which I know you will.
Thank you. So, going backwards, we've touched on grounds 1 and 2 already. At ground 2, is there anything else that you want to add about that?
Well, this is the point that we have already covered. I think perhaps what I would say is that although it's been said your predecessor conceded, I do submit that the judge didn't deal with it just entirely on the basis of a concession. In fact, if one looks at his judgment, he actually considers the matter with regard to construction. So again, I say that it is a factor.
And what do we gain from that? That he also looked at, if any.
Well, if I persuade, and at best it would only, I think, be two of you, that our construction is the one, is in effect, the only question was quantum, then the judge was wrong to treat the if any as it were allowing to treat the matter de novo. Now he could say, right, well, I'm simply basing that on counsel's concession, but he doesn't.
Okay, I understand that.
So to that extent, it is relevant.
Right.
And although Creasy and Soul is not going to be deployed under point 1, which I think the court's made clear, I think it is nevertheless instructive in the way that it says you look at the will and nothing but the will.
Okay, so that's ground 2, and then to go back to ground 1, which has been on the shelf for a long time now. Where we started in relation to that was, what do you say about why you should be allowed to argue on this basis now?
I submit it's the correct analysis. So it's right in law. It's a pure legal point.
So you say correct analysis, pure legal point. Accordingly, there's no reason why you shouldn't argue it now.
Hasn't prejudiced my learned friend. He's addressed it in his skeleton argument. And I would also submit that there was... It took 2 to send the judge down the wrong rabbit hole, my lady. If one is actually looking at this, what should have been said to the judge was, hold on a minute, actually, this whole premise is wrong. So
I hesitate to interrupt you, but to try to spread the, and I will put it blame only in inverted commas, it is a difficult stance to take, given that one has carriage of one's own litigation. But in this case, particularly, where in fact, if one looks at the skeletons below, the issue was raised by the defendants below, that Mrs. Ramzan couldn't have anything to do with occupation rent, in her own right at least, because she was a trespasser. So the bells were rung.
the case of Creasy, my lady, it is... The case of Creasy and Soul was not cited, and it should have been, on any view. And reference has already been made to rabbit holes. This was a slightly Alice-like world that the judge was then invited into. And the problems I submit that I have struggled with, I don't suggest your ladyships, your lordship have, but I have struggled with is precisely because one is trying to make it fit. But both parties cooperated in that process. So it wasn't just that my predecessor made a concession which I'm sure my Lady Justice Anders would disagree with me, I would not have made. But that...
I'm sure I'd agree with you that you wouldn't have made it.
I'm grateful, my lady. but I submit I would have been right not to make it. But the point is that that created its own problems. And there wasn't a claim made to say, stop this case now, and it's Crisian sold, and this has all gone horribly wrong. And had that argument been made, in fairness to my predecessor, then his approach, the concession which he made, was on the premise we were going to decide the case on the basis that we assume they were all entitled to occupy under the terms of the will, subject to exclusion, although he did say that we had been effectively excluded in that paragraph, that passage I've taken you to in the judgment. So I think that it's not a situation in which you just say, well, this point wasn't taken, and therefore it can't be taken in this court. There are consequences of doing that, which I have struggled with over this morning. But this court, in my submission, should be driven by arriving at the right conclusion, of course. And what this court also mustn't do is penalise me for the edgy bits which won't fit through the round hole, rabbit or otherwise, because both parties have proceeded on the wrong basis.
Well, the right basis may have led to the conclusion that your client had no locus standi to bring the action.
Well, my lady, it might have done, and in which case, and then we would have, my lady, if that had happened, we would then have returned to the effect of the consent order. There would then have been an unseemly argument as to its consequences, perhaps only in terms of costs, and there would then have been a further action to try and compel the, I'm sorry, my lady, to compel the administrator to take the necessary action. But because the case proceeded in the way that it did, all that has now passed. And I have simply struggled, and forgive me for sometimes simply struggling, to make sense of what happened. But I believe that it's still clear on the premise on which this case proceeded that the judge exercised his discretion on the wrong basis, and indeed, in his treatment of the question that I'll call ouster in its widest sense, he also erred, because the presumption should have been with us.
That in relation to this issue, namely whether you should be allowed to run the arguments in ground one at this stage, you've said to us that it's a pure legal point. There's no prejudice now in being able to the other side in being able to do so. Both parties cooperated in the mistake, let's put it that way, and it's the correct analysis. But can you help me in, because there's an exercise of discretion here, about whether you should be allowed to do this? Because I think you've, in effect, conceded that it wasn't run like this at all below. So we have a discretion about whether you should be allowed to do so now. And so what do you say about, and some of the things you said about detriment and pure legal point, etc., go to that. But what would you say overall in relation to the overriding objective about the exercise of our discretion?
Well, the overriding objective is to deal with cases justly. I don't suggest that dealing with cases justly doesn't just go to the procedure, but it must include the outcome. And you seem, if you're obliged to proceed without dealing with ground one, to be proceeding down a route which is wrong. And that, it seems to me, is an unattractive position. Can I also say this, though, because junior counsel acted in the trial below, and I accept his only incidental relevance. He is confronted by a proposition which, as we say, on the scale of numbers, so we say it's the first time it's raised, these are Part 8 proceedings. You don't have the benefit, therefore, of the parties focusing their minds. The witness statements don't address this issue, one way or the other. So you can readily see how this situation occurs. But what was conceded was that, as it were, everyone enjoyed a mutual right of occupation. It doesn't go beyond that, and it it doesn't unpick then how you resolve all the other issues, which the judge was obliged to do. He couldn't simply answer the question by saying, well, now you've conceded that the consent orders get set aside, I'm not dealing with the case because actually this should have proceeded on the basis of a claim for mean profits by the estate. He didn't do that. No one directed him to do that.
And in outline, in relation to the proper process, you say Creasy and Searle, Talata, section 12 and section 18, the right to an interest in the residue of an unadministered estate doesn't get you there.
Yes, it's as simple as that. It appears that, as I understand it in simplistic terms, where Talata applies, it is obviously the exclusive code, and that's Stack and Dowden, Lady Hale. Where it doesn't apply because you don't engage at stage one because you don't have a right of occupation, then it's more general equitable principles. We say those principles are guided by French and Barham for obvious reasons that we have considered. The judge, as I say, I think in his judgment, he got to a point where he worked out that somehow it's like doing an equation and you suddenly get to a point where you think, oh, this no longer works. So he jumps on and says, oh, but in the exercise of my discretion, I don't have to do this anyway. And that's not surprising because that's where I'm afraid the law took him. But you have my reasons as to why I say you should decide this case de novo, and those are the factors I set out to you, the ones that ought to lead to that conclusion. Right.
Thank you. Thank you. If you just give us a moment.
And we should put him on notice that they're going to expect submissions on whether they should be shut out.
Thank you, Mr. Dalton. Sorry about that. In all the circumstances, and we've heard what you say about whether or not you can rely on ground one and your submissions there, we'd like to hear in short order before the luncheon adjournment your submissions in relation to Creasy and Searle and the underlying issue.
Okay. It's really simple, but the case isn't because it doesn't have a head note. But in very simplistic terms, if one goes to Creasy and Searle, what one sees there is you had two wills to add to the complication for Mr. Justice Morgan about a farm on the Isle of Wight. Mm-hmm. And under father's will, I hope I get this the right way round, he left the farm, I think, half to his wife and then to the children, the other half to them in equal shares, like a residuary. So the effect of this will. Father dies first. Mother, when she dies, under her will, she leaves, and the defendant is known as Michael, Michael's land to Michael. The effect of that, as I understand it, is that under Michael's land, there was half a beneficial share that was owned by father's estate, and there was half a share beneficially that was owned by mother's estate. Mr. Justice Morgan found that in relation to, as it were, the residual, the situation as we have here, which is the beneficiaries taking in equal shares of residuary of the estate, that could not engage, could never engage Talata, with the simple fact that Michael was a trespasser, because he could never have a right to occupy the land. And he looked at it for a number of reasons, one of which is to say that what Talata is concerned with is physical land, a physical right to occupy the land. He found that in the case of mother's bequest, the issue was arguable, but because the two were interlinked, in other words, mother didn't own the whole of the land, the consequence of that was that Michael could not establish, even to Michael's land, a right of occupation so as to engage Talata.
And that was the doubt in relation to mother's land was because in the provisions of the will, there are also quite detailed arrangements about options for other siblings to buy, to allow Michael to buy the shares because there were 6 children. And so from that, I think the judge extrapolates accordingly that one might assume that there is something there about Michael being expected to be in occupation of what was called Michael's land, or that interest in Michael's land which was coming through the mother's estate.
Yes. So essentially, if you're bequeathed a property, then before probate is concluded, if you've got the property, then it hasn't been decided by Christian Soul, but you've certainly got an arguable case for saying you have a right of occupation for the purposes of Talata. And that's because you've engaged Section 18 to say, well, effectively the probate process is treated as a trust process. But if all you've got is a beneficial share, then you haven't, because you haven't got physical land, and that's what you need. And that sort of dovetails, and I hope I do justice because it's a monster of a case, and you can see, there's no head note. But
it is more complex than you have described, Mr. Darton, and you acknowledge that, and I'm asking you to deal with it very quickly. So we accept that. Thank you.
But the final point is that the sense of that comes in a case that my learned friend referred us to, which is the St Barnard's Homes Association case, which is just a tab 2. And I know, my lords, my ladies, you'll know this case better than me, but it's this point about what does a residuary legatee have? And the answer is, well, you don't have really anything in terms of a proprietary interest. You just don't.
Which case are you looking at now?
I'm sorry, my lord, it's tab 4.
Bernardo's.
Yeah, and it's page 32, my lord.
Thank you. 32 of the bundle.
Yes, I think that's where Lord Atkinson, I think that's the point. But it's amongst probate practitioners, it's sort of trite law, as it were, that you can't say, well, because I'm a residuary beneficiary, therefore I've got a 6th share in that physical asset over there. You don't. It's the same in any, really. It's the same in an insolvency or anything. Well, no, you've got in specie once we've actually resolved everything until you haven't got a right. And that's the point. And as I say, it's a very lengthy judgment. I hope I've done it justice by being brutal with it. But the conclusions of Mr. Justice Morgan are very, very firm, and I submit they're the right ones, wherever that takes us in relation to the outcome of this litigation.
And no doubt in this case you would say you're one's further from the target, because in that case one was looking at an interest between siblings in particular named parcels of land. Whereas here you've got an interest between siblings purely in a residue.
Yes, and I mean that is the answer in terms of its statutory in terms of its legal outcome. But it's always the case in wills that whatever mum and dad said, whatever they may have decided, you can only look at the will. Otherwise, we're all done for.
Thank you. Thank you very much indeed. I think although it's 5 to 1, it's an appropriate moment to break, particularly as I think that you both might like the opportunity to have a look at the case of FII group litigation versus the HMRC, which is in 2020 in the Supreme Court. And I'm sorry, I did have the precise reference of it, and now, aha, I do. I was going to say, and now it's nowhere to be seen. but it is 2020 UKSC 47, or 3 Weekly Law Reports 1369, in particular paragraphs 83 to 100, which deals with this issue about needing permission to raise a new point on appeal and the kind of factors which might be relevant. So I think that you might like a little bit of extra time in order to look at that. And to the extent that there's anything further you want to say about that, Mr. Darton, after the short adjournment, then of course you should do so. Thank you. So 2 o'clock.
Court rise.